Hi everyone, and welcome to today's webinar, My Idea, My Property. This webinar is part of the Law Awareness Weeks at CDC 2021, a collaboration between Law Society Pro Bono Services, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Science Services, Science School of Law, Singapore Management University School of Law, and the Singapore Corporate Counsel Association Pro Bono Chapter, supported by the People's Association. I'm your host, and my name is Abigail Tan. First, some housekeeping matters. Please feel free to ask questions at any time during the webinar using the Q&A icon located at the bottom of your Zoom window. We will do our best to address your questions during or at the end of the talk. There will be a QR code featured in the slides for you to scan to access the handouts made available for this webinar. A link will also be sent to you in the follow-up email tomorrow. Please note that the discussions and any material provided in this webinar is not intended to substitute or constitute as professional legal advice. You should consult a lawyer if you require any specific legal advice. With that, our speakers for today are Trina Ha and Gretchen Su. Trina is the Chief Legal Counsel and Director of the Legal Department at IPOS, where she manages the legal affairs of the IP Office, including supporting IP policy reform and advising on IP issues and international agreements. She jointly spearheads the copyright review with the Ministry of Law. Prior to joining public service, Trina was in the private sector where she specialized in matters involving the protection, management, and exploitation of intellectual property rights, particularly in the media and entertainment sectors. During her time in the legal practice, she was ranked annually since 2007 in the intellectual property industry and the TMT industry by the Asia Pacific Legal 500. She's also listed in the 2020 and 2021 editions of the IM Strategy 300, the world's leading IP strategist guide. Also with us is Gretchen Su. Gretchen is an intellectual property specialist and is highly experienced in the protection, commercialization, and enforcement of intellectual property rights. She's an accredited mediator with the Singapore International Mediation Institute and accredited as a Certified Information Privacy Professional Europe, CIPPE, with the International Association of Privacy Professionals, IAPP. Thank you, Trina and Gretchen, for joining us today. To give our audience a sense of what to expect, I will outline what we will be discussing in this webinar. First, what are intellectual property rights? A brief introduction into copyright and trademarks. What are intellectual property rights that are so important for a social media user? Updates to the Copyright Act. And of course, we will then go through hypothetical scenarios where our speakers will discuss the interplay between the intellectual property rights and that of the social media user. So in terms of IP rights, what should social media influencers and content creators be aware of? They will need to be aware of IP rights in order to understand what their rights are and how to prevent inadvertent violation of others' IP rights. The domain for IP rights is very broad. However, the main two tenets relevant to content creation process or social media influencers that we'll be discussing today will be focusing on copyright and trademark rights. Gretchen will be providing an overview of IPRs in relation to copyright and trademarks. Gretchen, please.
Thanks, Abigail. Hi, everyone. Yes, as Abigail has mentioned just now, IP rights is a very broad topic. But for the purposes of today, I will first give an overview of what are IP rights, because I still hear a lot of there's a lot of confusing language used around. So can I have the next slide, please? Okay, this is an overview of the types of IP rights. Because I still hear people telling me that I want to patent my trademark, I want to copyright my trademark, and so on. So to give an overview, these are all different types of IP rights. Okay, so for copyright, it's an expression of an idea, and there is no registration required. And then for trademarks, it's an indicator of source and quality, and trademark registration is possible, but it is not mandatory. So these are the two types of IP rights I will cover more in detail. The rest are not so much relevant to people, content creators online. So I will skip those. Okay, next. Yes, so for IP rights, as you can tell from the name, intellectual property, which we also refer to these days as intangible assets. The nature of property and assets is that you are able to extract value out of it. So how do you do that? You do that by exploiting the IP rights. So for example, if you just use an analogy of, say, a car, I can sell the car, I can get money out of it, and I can loan it to somebody, and I can also get money out of it. So in terms of IP rights, the main ways of exploitation, in other words, extracting value out of it, is by selling, then by licensing, and by financing, which is to secure financing, say, from banks, investors, and sponsors. For licensing, this is a very broad topic. It can be very flexible. You can consider what are the different rights you are going to license to different people. You can consider the duration. The license can be for a fixed period. It can be for perpetuity. It can be for a specific territory, say just for Singapore, or it can be worldwide. Exclusivity means whether or not the person you're going to license is going to have the exclusive right. That means they will be the only person with the right to use the particular right that you're going to grant to them. Or it can be non-exclusive, which means that you can go to multiple parties. So for specific purposes that you are going to list out. So we will talk about a bit about licenses later. Okay, next. So the first trademark I'm going to go into detail about is the first type is trademarks. So you will see that there are two familiar symbols on this slide. One is the R symbol and one is the TM symbol. So what is the difference? So basically the TM symbol just means that this mark, okay, say it appears next to a name. So let's say Taylor Swift or Fenty Beauty by Rihanna. Okay, so it means that this is being used as a trademark. You can only use the R symbol if the mark is registered. So that is the difference. One is just a general indication that this is a trademark, and R means that this is a registered trademark. So, so as mentioned before, for trademarks, you can register it or you can choose not to register it. The difference is that unregistered marks, while they are protected under the law of OSIC passing off, the problem is that the burden of proof, if say someone has is going to use a similar or identical mark to yours, if you're going to bring an action against them, the burden of proof for you will be much higher, which is why if you are going to be using it as a trademark, you are deriving value, you're selling products or you're selling your offering your services, and you will be commercially damaged by someone infringing this, then the recommendation will be for you to register it, because you will have a lower standard of proof when you try to enforce it. So what is the benefit of a registration? The registration is that when you get a registration, typically the term will be for a period of 10 years, and every 10 years you can renew it. So in other words, a trademark that is registered can potentially have indefinite period of protection as if you keep renewing it. Okay, it is also a territorial right, and by what we mean by territorial right means that it is restricted to the country where, or the territory where you are registered in. So say that you register a trademark in Singapore. It is only grants you the exclusive right, a monopoly to use that mark in Singapore. It does not extend to a foreign country. So that's why major brands will have to register their trademarks in pretty much all of their markets. Okay, so how does this affect content creators online? The trademark can be, say, your name. It can be your online handle. Say, for example, the OG influencers in Singapore will be Mr. Brown and Xia Xue. These are not their names. These are not their true names. So they can actually register that as a trademark, okay? Because this is a name, a sign that acts as a badge of origin of their products and services, okay? And so this is how an influencer can, say, protect their name, their online handle, which is very precious to them, or say that you are someone who creates videos. You have a logo that's associated with your videos. There's a watermark on all of your videos or say your photos, and that is a logo that you have designed exclusively for yourself. That logo can also be a trademark. Okay, so these are trademarks that, I mean, this is how it will, this applies to online content creators. Next. Okay, so what if you find that somebody is using a trademark that is very similar to yours, what are your remedies? When I'm talking about infringement, this means only applies to registered trademarks. So when you have a registered trademark, you can enforce your right by bringing an action against that third party who's using a trademark that's very similar to yours. When courts look at this case, they will consider a three-step test. First, you have to put the marks side by side and you compare them for similarity. Then the second step will be comparing the goods and services that the marks are being used on. So say that you are using your mark on makeup, for example. Then they will look at the other party, what are they using the mark on? If it's on a completely different type of product, say handphone accessories, then there is no similarity in the goods that you're providing, and there will be no similarity. That there will be you will fail the second test. It is only after you have fulfilled the first test, that means the similarity of the mark. Secondly, similarity of the goods or services, then the court will consider whether there's a likelihood of confusion on the part of the public. And the public in this case will refer to people who are the relevant public, the people who will consume the goods and services that you provide. Okay, so it doesn't necessarily mean like the whole of Singapore. If say that your product or service is a very niche product. Okay, so this is a three-step test that the courts will consider, and this is only applicable to registered trademarks. For non-registered trademarks, there's a law of passing off, which follows a similar but not identical query of whether firstly you have to establish that your mark, you have reputation in it, and then you have to show that someone else has infringed it, or rather used it in a way that damages you. Okay. So the thing is that it is usually very hard to start the action because it is firstly difficult to prove that you have the necessary reputation or fame, especially in the context of online content creators, because how many followers do you need to prove that you have reputation and fame? That is still a very nebulous area where you need a lot of evidence and it is difficult to prove. Okay, so the recommendation is that if you are a content creator who you are actively using your brand to sell products and services, and you will suffer commercial damage if someone infringes it, then the recommendation is for you to register it. Okay, next, please. Okay, so that was an introduction to trademarks. I'll now cover copyright, which is a very, very broad topic. The copyright will cover works, okay? In general, these are the different types of works. So this is after the recent passing of the copyright bill. The main areas will be authorial works, okay? The ones that will apply to content creators will be authorial works as well as films and perhaps sound recordings, okay? So authorial works will be literary, it means any work you write. So, in the original OG days when people used to write very long blog posts, yes, that is a literary work. Then dramatic work can be a skit that you put up or even a dance routine. Artistic works means things that you draw, for example, or photographs. Okay, yeah, in the case of content creators, most likely it will be photographs. And then musical works, if you create music. Then for films, this will cover basically online videos. So people who are active on TikTok and YouTube, this is where your copyright, this is where the work that you create is classified under. Next, please. Okay, so what is an infringing act? Okay, basically it means these are the different areas, but the one that most content creators will be concerned with will be doing any act that is comprised in the copyright. So when you have a copyright, say I own the copyright in this video that I created, okay? So what is your exclusive right? Your exclusive right is that as the copyright owner, I have the right to make any copy of my work. I can publish it, I can perform it in public, I can communicate to public, means I can stream, I can put on any platform I like, I can make an adaptation. Make an adaptation means, say, for example, say a context of a song, okay, you can change the lyrics, for example, and make another song, okay? So these are the exclusive rights for an owner of a work. So if someone else does any of such acts which are without your permission, that means without your license, then they will be infringing your copyright. The rest of the other infringing acts are not so relevant to online content creators. So okay, I'll skip that. Okay, next please. Okay, so what happens when there's an infringement? Okay, so okay, say that you are an online content creator. You have a choice as an owner. You can start a civil action. A civil action is, as opposed to a criminal action, is that it is started by a private person, okay, or a company. Whereas criminal means that, say you lodge a report with the police and say that someone is infringing my copyright, and the police decide that they're going to take action. This is okay. This infringing consequences, this applies to trademark infringement as well. So there are civil and criminal. But I would say that you only need to look at civil because the police do not typically take action, criminal action, in a lot of infringement cases, unless they are really egregious, like say someone is selling counterfeit goods. Like I think recently there was a case where they raided a shop in the textile center or something, where they are doing people who are live streaming selling of goods which turned out to be counterfeit. So typically this will only apply. Criminal charges will only be pressed in such cases. But otherwise, it will be a civil suit brought in by the private person, meaning the copyright owner suing somebody for infringement of their copyright or their trademark. And what are the remedies that you can get if you are the content creator? You can get an injunction. An injunction means an order from the court. The most typical, most common order will be basically an order to stop doing something. Say, stop infringing my copyright by, say, taking down my photo or taking down the video from wherever you have posted it. So that an action to do something. Or in this case of something that is that means that a physical object, say merchandise, okay, that is, say it has a copyrighted works on it. Okay, they can ask you can ask the infringer to surrender it. There's a delivery up, or to destroy those infringing products. So basically this is a court order. And then the other remedy will be money. So in this case, you will have to choose. There are different types of calculation of what is the money that you can ask for. One is damages. Firstly, that means if you can prove that I have suffered actual loss because of this infringement, then you can tell the court, okay, I have, if not for this person, I could have sold these for how much, and this is due to me now. So that is your damage by you calculating how much. Or if you're unable to, calculate how much you could have earned from that, you can ask them to account for their profits. That means the infringer has to surrender whatever profit they made of this. Or you can also opt for statutory damages, which is, it's a set amount, which is about $10,000 per infringing work. Okay, so but that one is subject to a cap, and this is it. You usually only ask for this if, say, that the monetary damages or the account of profits is very, very low and does not justify the case. Okay, or it is just difficult to calculate. So basically, these are the orders that you can get. You can get an order to stop. You can get some money out of it. That is the only remedy available. Okay, next. Yeah. So if you want to avoid getting into this situation as a content creator, because you don't want to end up getting sued by someone, first, the recommendation is that you should always get permissions. If you're going to use someone else's work in your work, that means say, I'm going to make a video. Okay, I want to use some music as background music. Whose music am I going to get? What song is this? Okay, identify the work you intend to use. Identify the rights that you need to use the work. So I want that song. I need a musical work. I need the right to reproduce. I need the right to communicate to the public because I'm going to be publishing my video containing this song on YouTube, for example. And then identify the relevant person or the company, organization to get permission to use the work. And surprisingly, it's actually very easy to get permissions, because if, say that you're going to use a photo and it's published online, you know, you can contact this person by, say, their Instagram. You can DM them, or you can on Twitter just DM them. Or if you're trying to use a song, say a very popular song, okay, and you know that I will probably not be able to get in touch with, say, Taylor Swift herself, or Sam Smith, or whoever. So in those cases, you can go to a collective rights management organization. Next slide, please. So these are the major collective management organizations in Singapore where you can generally get permissions for your use. So the most common one that we get in, you will need in Singapore will be Compass. They represent composers and lyricists. So generally, if you want to, say, use a song in a video, say, or you want to use lyrics, you just apply. They have a website. They have forms that you can submit and pay a fee. Okay, these are the most common ones. And then in other cases, if, say, that you want to incorporate a short video in your video, then you can get to contact the motion picture licensing company. So these are the general CMOs in Singapore that you can contact and get permission. Okay, I think next, please. Yeah, okay, so because there's been very major changes to the Copyright Act, as some of you may have noticed, where Parliament just passed the Copyright Bill. I will now pass this to Trina to highlight the changes to the Copyright Act.
Thank you, Gretchen, and good evening, everyone. I'd like to thank the Law Society Pro Bono officers for inviting me to share on the new Copyright Act, which will come into force late November this year. So Gretchen has laid out very nicely the basic principles of copyright law, and I will go into how the Act has introduced certain key changes that will affect you. But let's start off with some background to this new Act. It is a combination of the most extensive review of the original Copyright Act enacted in 1987. This was a joint review by the Ministry of Law and IPOS on how technological and market developments have significantly impacted copyright law. The review started back in 2016 with the very first public consultation, seeking views on over 16 proposals. This has been a very extensive exercise with multiple public engagements over the years on different issues. Now, in terms of the legislation itself, it is the first IP legislation in Singapore to be simplified for the public. It has been completely rewritten with a new and hopefully more intuitive structure, and is written entirely in plain English to aid understanding by everyone. Now, this is not a final review. The law has to constantly evolve to take into account ever-changing business norms and rapid technological advances. Ministry of Law and IPOS will continue to monitor, and we take on board feedback from our stakeholders to ensure that we have a copyright regime where rights are reasonable, clear, and efficiently transacted. Next. So you will see on this slide before you, in a nutshell, all the different changes that will take place under the new Copyright Act. It falls largely into three buckets and covers a wide range of stakeholders, from new rights and remedies for creators and performers to new exceptions for users to ensure that you can reasonably access works for societal benefit and to support innovation. There are also changes to strengthen the ecosystem, which includes a new licensing regime for collective management organizations, the ones that Gretchen referred to earlier. And this will not come into force in November this year because we will consult on the draft license terms and conditions next year and hopefully bring the license scheme into force towards the end of the year. Now, I'm pretty sure the audience here, a lot of you are content creators. Some of you may be thinking of or already are social media influencers. You're very active in the digital media space. You are both content creator and user as well, because a lot of times in creating content, in creating videos, you actually might end up using content from other people. So let's move into the key changes that will affect you as both creator and user. There are three key changes that I'm going to touch on today. There has been a change in the default ownership of the copyright of certain commissioned works. There is a new right of creators and performers to be identified. And I will speak on the changes to the fair use exception under our law. So let's start off with the first change. Next, okay. Now, under the current Copyright Act, creators own the copyright in their creations by default, except in the case of commissioned photographs, paintings, sound recordings, and films, where the commissioner owns the copyright by default. The new Copyright Act will reverse this position such that there is consistent treatment across all types of works. So commissioned creators will own the copyright to all their works by default. This includes photographs, illustrations, graphic designs, and music. So what does this mean for you? Well, by default means that if the contract is silent on ownership of copyright in the commissioned work, then we go to the law to see who is the owner of the copyright. So if the commissioning contract is silent on who's the copyright owner, then the creator is by default the owner. But parties can agree in writing to reverse this default position such that the commissioner owns the copyright instead. The long and short is that it is good business practice to get all this down in writing in a contract between you as the creator and your client, or you as the client and the creator as the person you are commissioning to do work for you. This contract should state very clearly who will own the copyright in the work so that nobody inadvertently loses copyright. The contract should also state what rights does the client have in the work and how they may use the work. And the contract should also state what rights the creator has in the work and how the creator may use the work. Now, this is especially important for creators. Say you have agreed to sell away the copyright in the work to your client for a good fee. But you may want to reserve certain rights of use for yourself, because once you have assigned it away, you actually no longer have any rights to use the work, but you may want to actually use the work in your commercial portfolio, to feature it for marketing on your website, maybe even to enter exhibitions. If you want to have certain users to your work, even though you agree to assign copyright to your client, you must put it down in the contract. Next. Other laws continue to apply, such as personal data protection laws, defamation, and criminal laws. This is really important to bear in mind. Let's talk a bit about the Personal Data Protection Act. So under the PDPA, the Personal Data Protection Act, a photo of an individual that features an individual, like portrait photography, family portraits, wedding photos, graduation portraits, that photo constitutes the personal data of the person who is the subject matter of the photograph. Even if the photographer owns the copyright to the photos, it does not mean that he can do whatever he likes with the photo, because it's the individual's personal data and he must get prior written consent. So take, for example, a family portrait. And under the terms of the contract of the photography studio, the studio owns the copyright to the photos. But it doesn't mean the studio can just put the photo up online, distribute it, put it in their marketing brochures. They need the prior consent of the family members who are featured in the photos. And it's good to bear in mind that consent can also be withdrawn by the person who's the subject of the photo. Next, please. So we move on now to the new right of creators and performers to be identified. Under the new Copyright Act, all users must identify a creator or performer in a reasonably clear and prominent manner when using their material in public. Examples of users in public, depending on the type of content and manner of use, would include sharing it online like social media, publishing it, even including it in corporate collaterals. And what is reasonably clear and prominent depends on the type of content and the manner of use. And if you are a creator whose right to be identified has been infringed, and your remedies will include injunctions, as Gretchen earlier explained. And in this case, injunctions could be a court order to perhaps stop use, take down from your social media account the work, or to require you to add in a credit to the creator or performer. Now, if you have suffered monetary loss, you could also claim for damages. As with all aspects of copyright law, there always must be a balance. And in this case, there's a balance to be struck between protecting the rights of creators and not imposing too heavy a burden on users. So there are certain exceptions where you do not need to identify the creator or performer if the creator or performer's identity is not known, if the creator or performer consents to not being identified in that particular situation or platform, or relinquishes their rights completely, and this is done through a waiver in writing. Or the material is used for an exempted purpose, like artistic work in public places, or incidental inclusion of the work in films or television broadcast or cable program, or if the material in question is an exempted material, like employee-created work. Next, please. So what does this mean to you as on social media, as both content creator and also a user? You can assert your right to be identified against those who use, share, retweet, repost your content without identifying you. But you also need to credit the creator of content that you yourself use, share, repost, retweet, etc. Now you will see here on screen 2 examples that we have come up to show you how this can be done. It's really not difficult. You just need to identify clearly who is the creator of the work that you are sharing. So there's a retweet function for Twitter. You can name the creator in the caption in Facebook. So these are just some examples. You will see them quite a lot actually on social media. Next, please. Now, this is very important to emphasize. This new right to be identified coexists and is separate from copyright, from that of copyright ownership. The right to be identified, or sometimes called the right of attribution, is personal to the creator. It cannot be assigned or sold away or transferred to someone else. So what this means is that if you intend to use a work, not only do you have to identify the creator, you also have to get permission from the copyright owner to use the work, or you can rely on a permitted use if you do not wish to get permission. And sometimes the copyright owner may be different from the creator. As Gretchen explained earlier, IP rights are things that can be sold away as well. So if a person has bought copyright in a work from the creator, the new owner must still identify the creator whenever the new owner uses the work in public, unless of course it is an exempted work or any of the exceptions apply, or he has gotten the creator to waive his rights in writing. Let me go through another example for you. Let's say you are a children's book illustrator and you have entered into a publishing contract to create illustrations for a book. And in the contract, you have assigned away your copyright ownership to the illustrations. But you have retained your right to be credited as an illustrator. So the book gets published and it says illustrated by XX. And the book is very popular. So someone reproduces extracts of the book featuring your illustrations without permission and without crediting you as an illustrator. So what happens? The publisher can sue for copyright infringement of the book and the illustrations as a copyright owner. But you, the illustrator, still have a separate right of action to take against those who have reproduced your illustrations without crediting you to get yourself to be identified as an illustrator of those reproductions. So I hope this explains how this new right of identification coexists and interoperates with copyright ownership. So I'll now move on to the third change. Next. Okay, so Gretchen talked about copyright infringement. But under copyright law, there are also exceptions to copyright infringement. It means that it's a permitted use by law, and you do not need to first seek consent from the copyright owner to use the work. Now, exceptions are very carefully crafted to ensure they do not go beyond what is reasonable to fulfill a certain benefit to society while still protecting the rights of creators. Now, under the current Copyright Act, and which will continue into the new Copyright Act, there are already exceptions. For instance, fair use of works for news reporting, fair use of works for criticism and review. But the new Copyright Act will also introduce some new important exceptions. For example, there will be a new educational use exception for non-profit schools to use freely available online materials for teaching and learning. There are also new and updated exceptions to allow galleries, libraries, archives, and museums to help them in fulfilling their mission to preserve and to exhibit our cultural and historical heritage. But this evening, I would like to go into further detail on what we call the fair use exception. Next, please. Now, unlike the other exceptions that I just mentioned, which are very specific as to the circumstance and conditions of use, this is a very broad, open-ended exception. Simply put, it is a permitted use of a work to make a fair use of the work. The key thing is it fair? And to help the court decide whether it is fair, the Copyright Act lists down certain statutory factors. You see on screen now 4 factors: the purpose and character of your use, including whether it is of a commercial nature or for non-profit educational purpose, the nature of the work you're using, what is the amount and substantiality of the portion of the work you're using in relation to the whole work. Are you using it all or only an extract of it, only a certain portion of it? And the effect that your use will have on the potential market or value of the work. Now, these are what we call mandatory statutory factors, which means the court has to consider this in every circumstance. But it is not an exhaustive list of factors. There are other relevant factors that the court may also consider depending on the circumstances of the case. So it is really a factual determination. Now, under our current Copyright Act, there's actually a 5th factor: the possibility of obtaining the work within a reasonable time at an ordinary commercial price. The new Copyright Act will remove this factor. It will no longer be a mandatory statutory factor to be considered in every situation. Why did we remove it? Well, this 5th factor was adopted way back in 2004 when copyright works were largely distributed in a physical medium and they might have been difficult to obtain. But current technology, digital landscape and globalization means that it's increasingly uncommon for copyright works to be unavailable. And with all these new social media platforms and how content is used and distributed, where we can use music for home videos, and not everything is commercial use, well, this last factor may be less relevant. And some might even say it's subsumed under the 4th factor when you talk about the effect on the potential market or value of the work. So as such, not to complicate matters, to make this exception easier to use and understand, and also adapt to ever-changing market practices and technology, we removed it as a mandatory factor. However, in a particular circumstance, it might still be relevant, and it is still open to you to bring this factor as part of your defense that your use of the work is fair. Well, this brings me to the end of my presentation on the key changes under the new Copyright Act that will affect you. So I will hand this time back to Abigail.
Thanks, Trina. Thanks, Gretchen, for sharing. Now, before we move on to our hypothetical, we actually have a question from our audience. Let us invite Gretchen back for this discussion. So one of the questions that was asked, someone appears to be using my work as source material, but instead of directly copying and pasting, the person paraphrases the content before reproducing it. However, the ideas and structure are substantially the same. Some of the content has up to 30 to 40% similarity according to the plagiarism software that was used to compare. No permission or credit was given. Are there any remedies for this? Trina, would you like to take this question?
I think it's such a factual determination as to whether there is copyright infringement. So, when I used to give talks on copyright, people will ask me, is it a 40% rule of thumb? Is it a 10% rule of thumb? There really isn't. Now, under the Copyright Act, which will still be the new Copyright Act, you cannot reproduce more than 10% of a book or more than one chapter. Usually that refers to photocopying, You know how as students use to photocopy. And we always tell people, you can't have one person copy 10%, I copy 10%, and then add it together. But when it comes to this kind, where you take the idea, you represent it in a different way, I think the question is, did you take something that was qualitatively significant to the work that you're copying? such that it brings to mind the original work. And it can be as short as the opening 4 bars of a song, or a certain line in a film that is so, people just associate it with that film, and it's so clear that you have misappropriated that line. So there's not, unfortunately, no real hard and fast rule, no hard and fast answer, but these are the guidelines. Yeah, I don't know if Gretchen wants to add on to that.
Yeah, I think, as Trina mentioned, as it is really hard to say, in any particular case without examining them side by side to actually come to an answer. But I think one of the things that we always mention when we introduce copyright is that ideas are not protected. It has to be the form in which it was recorded. That means the way that you wrote it down. So even though you say that the structure is the same, the idea is the same, but if they change the words substantially enough, it is still possible that it becomes a completely different work on its own. So again, as in, even though you say it's 30 to 40%, we have to see exactly like that there has to be a quantitative and qualitative analysis, because it could be that this book or this whatever work that you created, the main thrust of the argument is A, but the other person rewrote it such that the main thrust of the entire essay is now B, where even though they may have taken some ideas from your work, now the new work is a completely different work because it argues for something else. So again, it really has to be examined on a case-by-case basis.
Thanks, Gretchen. Thanks, Trina. So then what would you suggest that this person do as a next step? For what can they do if they can't is to access on a case-by-case basis? So how do they go about finding a way
to ensure that they do not infringe copyright?
To a remedy for this person, because he's saying that someone else might have infringed his materials. What can he do? What are his remedies?
Well, okay. I mean, the first step is not always to sue. Okay, a lot of people think, oh, immediately I have to go to a lawyer and pay thousands of dollars and bring a court action, which will take like 2 years of my life. No, it's actually not that complicated. Initially, you can send a written demand to the person whom you think has infringed your work. It's what we call a cease and desist letter. And you can tell the person that you have copied my work, to please stop copying or take it down from, whatever platform you put it in. And if you have suffered monetary loss, to request for compensation. And it doesn't mean that once you issue that letter, then you have to go to court. A lot of copyright infringement disputes are actually settled through private negotiation. A large part of it depends on how much you're claiming as well. And also, how similar the work is to you. So sometimes it can be settled by private negotiation, or you can even go for mediation, like at the Singapore Mediation Center. Now, let's say you're really not sure what you should do, right? As you say, seems like the person is copied, but I hear Gretchen and Trina talk about qualitative significance, quantitative significance. Well, the good news for you out there is that IPOS has this IP legal clinics. So it's open to Singapore citizens, Singapore residents, Singapore registered businesses. And you can go and get legal advice from a lawyer selected from a panel. It's 45 minutes. And the fee is fully reimbursable by IPOS. So the clinics are for people who need to know how to enforce their rights if they think it has been infringed, or who are the subject who have a claim of infringement made against them. Yeah, so it's a good starting point if you're not really sure where to begin. And the link is on the link to the IP legal clinics are on the resources. You see them now, the QR code, as well as the URL, which you can go there and you can book an appointment with a lawyer of your choice from a panel of law firms.
Thank you, Trina. That was really helpful. So for the audience, please scan the QR code if you want to know more about the resources and the IPOS IP clinic that Trina had mentioned. Now, feel free to drop in your questions into the Q&A chat box anytime during the course of this webinar. Now, let us move on to the common case scenarios that, so we have come up with a hypothetical and we will be discussing this with Trina and Gretchen. So in the first scenario, we have Instagram influencer Mary, who has been engaged by a famous makeup brand called Beauté Beauté wants Mary to take photographs featuring herself using Beauté products and post these photographs on Instagram to her followers. The photographs were taken by John, her photographer. So in their agreement, Beauté had included this clause. It says, Mary hereby with immediate effect agrees to assign to Beauté all intellectual property rights belonging to her or any of her associates, whether existing now or to be created in future, that arises from the content created for Beauté products. Now, of course, Mary should be very careful before signing the agreement with Beauté. Given that John is the photographer, who then owns the copyright to these photos? Also, as Trina had mentioned earlier, there might be some implications from a personal data protection angle. Trina, would you like to walk our audience through this implication from both a copyright law and a personal data protection angle, please?
Sure, thanks, Abigail. Okay, so under this clause, which is an assignment of all rights, intellectual property rights that belong to her, to Beauté. So Mary must first ensure that she has a copyright in the photos in order to then assign it to Beauté. So John, her photographer, has taken the photographs for her. I'm going to assume John is not her employee, could be her neighbor, could be a freelance photographer, a friend, but she will get him to take the photographs. So it is important to have some kind of, at least a very simple form contract at the very least. If he's a professional photographer, please do have a more formalized contract to say very clearly that Mary owns the copyright. Because if she doesn't say that, then under the new Copyright Act, by default, John will own the copyright. And Mary is in no position to assign the copyright away to Beauté and might actually find herself in breach of this clause. So that's the first thing she has to ensure, that she has a copyright to the photos. And then under this clause, she assigns it away to Beauté. So now you would think that Beauté as a copyright owner would be able to do whatever they want with the photos. But because the photos feature Mary, they constitute her personal data. So actually in the agreement, Beauté must be very clear how they intend to use these photos that have her as a subject matter, and Mary must consent to it. Now, Mary as well should also consider, would she need use of these photos for other things? Maybe she wants to use them on other social media platforms. Maybe she wants to use them in some kind of commercial portfolio because she, maybe she's also a model on the site and she wants to show it to other other brands that how she could be a brand ambassador. So if she thinks that she could use these photos for other users, then she must also clearly state that in the contract. So all these rights of use must be carefully negotiated. Yeah. So that's what I think it should be done.
Thanks, Trina. That's very helpful. So let's say the scenario had changed. What happens if it wasn't John who was the photographer? Would that make a difference in your answer?
So if she were to take the photographs herself, then clearly she's the copyright owner as the maker of the photograph. Then after that, it just flows. She is of course free to assign the photos, the copyright in the photos to Beauté. Yeah.
Thanks, Trina. So let us move on to another clause that is found in the scenario. So in scenario 1B, we still have Mary and Beauté. In the agreement, there's another clause called clause 2, which states that Mary hereby with immediate effect agrees to license on a sole basis to Beauté all intellectual property rights belonging to her or any of her associates, whether existing now or to be created in the future, that arises from the content created for Beauté products. So what does the term license on a sole basis? What does this mean? Gretchen, would you like to take this one?
Yep. Yeah, so just to clarify, as in this is a second scenario, so you can forget about the assignment, okay, because you cannot have both in the same agreement. Okay, so in this case, Mary did not assign the copyright in her photos. Instead, she's giving it on a license. A license, as previously mentioned, is one of the ways that you can gain value, which is that even though you retain ownership, you grant permission, say in this case to Beauté, to the IP rights in the works that were created, which was the photos that were created, okay, for the photograph. And in this case, they say it is on a sole basis. So these are the different terms that you will come across when you see a license. So a sole basis means that Beauté will be the sole only, that means sole means only a party that's able to use this work. At the same on the terms and conditions of this particular agreement. Okay, but it also means that if it's sold, and then Mary cannot assign or license it to anybody else. But at the same time, because she's still the owner, okay, she has the rights to exploit the copyright herself. So that means this is actually more beneficial for Mary, this particular clause, as opposed to the first one where she assigned it away, because she remains the owner. She can use it, and she can post it and use it in whatever way she wants, except that Bote is the one, is also a licensed and allowed to use this. And she cannot license it to, say, another beauty brand. Yeah.
Thanks, Gretchen. And as Gretchen mentioned, there are multiple terms in which they can license. So one is license on a sole basis. And what happens if in an alternative scenario, we have the terms license of a non-exclusive basis? So what does this mean for Mary in terms of copyright law? Trina, would you like to elaborate on how it would differ if, let's say, the licensing was on a non-exclusive basis?
Okay, so as Gretchen was saying, sole means that there's only one licensee who can use the work. Non-exclusive, well, the name speaks for itself. Bote would not be the exclusive user of the work. So Mary can actually assign the use of these photographs to other people, maybe other brands, or maybe she can license it away as stock photography, license it to magazines who need, photos of influencers. The only thing I would say from a commercial point of view, because these are product endorsement photos, right? It's quite unlikely that Bote will agree to a non-exclusive license because they feature their brand, their products. It's not very likely that they will say, okay, fine, I'll just take a non-exclusive license. Now, especially if there is some monetary payment to Mary to take the photos and to be a brand ambassador. So, I mean, from a very business commercial point of view, the first two scenarios will probably be more likely, where either Mary has to give away copyright, but retains some use, or Bote becomes the sole licensee of the work so that Mary can still use it. But there may be certain restrictions of use, because I'm very sure that there will be other terms in the contract that control the use of the photos, either by Mary or by Bote.
Thanks, Trina. That is indeed very helpful. Let's look at another alternative scenario. What happens if Mary was being accused by another content producer of reposting the content without proper attribution? So what are the defenses that Mary can have under this scenario? Trina?
Okay, so, well, the first most obvious one, because we see without proper attribution, is that the content producer will have a claim against Mary under the new right of identification to say that Mary did not identify him properly, right? So she would, so it's a factual determination. Did she or did she not identify him in a clear and prominent manner that this is his content? That is at the very first instance when we talk about attribution. Then we also have to remember that there is a separate issue here on copyright infringement, where she reposted it without, I'm assuming that since she's being accused, that she probably posted it without permission as well. But here it gets a bit tricky without going into the actual factual circumstances. For instance, how did she post it? What was the content? Did she copy all of it or only part of it? For instance, let's say she is a photograph let's say it's a poem and she posts it, but she compares it and does a criticism of it with another piece of poetry by someone else. It could be a fair use for literary criticism or review. So for what purpose? So whether or not there's copyright infringement, this is a perfect way of saying how it's very hard to just off the cuff say whether there's infringement without knowing all the factual matrix around it. But long and short, on the new right of identification, it's actually very simple. If you use somebody's work, please identify the creator.
Thanks, Trina. And yes, you're absolutely right. And this goes back to the first question from our audience when he was asking, what about the content without proper attribution? And does it mean that 40%, 50%? As you rightly pointed out, it's on a case-by-case basis. So let's now move on to Mary again. But now, instead of copyright laws, let's look at how trademark laws would apply. So in this alternative scenario, Mary, still an influencer, is a makeup fanatic and decided to create her own makeup line called Beautylicious with the bright red sign B. Another makeup line going by the name of Beautylicious with the bright blue sign B has registered their trademark and operated in Singapore for over 10 years. They would like to sue Mary for an infringement of their trademark. Can Beautylicious with the bright blue sign B make out a claim of trademark infringement? I mean, Gretchen, what do you think? Quite apart from the fact that they have also registered their trademark, they've also operated in Singapore for over 10 years. Would we be able to talk about, say, can they bring an argument on maybe this well-known mark?
Yes, certainly. Under I think earlier we had already talked about trademark infringement and the three-step test. So in this case, it is a bright red sign B as opposed to a bright blue sign B. Okay, so in terms of comparing the visual similarity of the marks, I think there is a very high level of similarity there. And if you compare the goods that they registered, that they are using it on, one is makeup and the other one is also makeup. So there's identity of the goods that are used, they are using on. So the second step is also second criteria also met. So now we move on to measuring the likelihood of confusion. So this is under the Trademarks Act. And when you look at in terms of well-known brands, which is why we have put in here in this case scenario that they have been operating for 10 years, which is a sufficient amount of time for them to gain a reputation and to argue that they are well-known. Well-known means under the Act means that it's well-known to the general public. That means the person on the street will know, okay, this logo belongs to this company and then they produce makeup, for example. So this is a fact that they have to prove in court. If say Beautylicious, the one with the registered trademark, they will have to prove that they are well known. But even if they fail on this to say that they are well known, they will still have a trademark registration. And on the face of it, they can say that there is an infringement because the mark is the same. Or highly similar, the goods are similar, and there is a likelihood of confusion on the part of the public. Okay. It's just that they can get additional remedies in case that they are, they can prove that they are well known because the level of the damages will be higher. But the thing is, Mary will have to, I think she could have avoided this whole situation in the first place, because but before you start a brand, one very good idea, at the very least in this market that you're going to start up in, you should actually do a trademark search, because when you have a registered trademark, it means that your trademark is on the trademarks register. It's a public register that anyone can look up and anyone can check. So in this case, if Mary had already done a trademark search before she launched her entire brand, did all of the work in creating the products and did all the marketing, she would have found out that, hey, maybe I should come up with a different name. So perhaps, Trina, would you like to talk about IPOS? They have a wonderful tool.
Yeah, so actually the register that Gretchen was talking about, the trademarks register, it's available to the public. It's searchable for free. It's online. You can either access it through the IPOS website, or we have actually launched about a couple of years ago a mobile app. It's called IPOS Go, G-O, and you can actually search for trademarks, registered designs, patents on that website, on that app. You can actually even apply to file a trademark for registration through that app. So in that resource link that I mentioned, there is actually some explanation about this mobile app. So the search is free, definitely. And it's very quick. It can be done very fast. You can search by a word. You can even search by image. And the search results will not only show you the brand that's registered, it will also show you investment of what goods or services. Because as Gretchen had explained about trademarks earlier, maybe there's a similar brand, but they are for shoes, whereas yours is for makeup. So there might be the fact that it's for such different goods, you might still be able to apply for registration. And it will also show you who is the trademark owner in case you wish to get a license or negotiate some kind of coexistence agreement. Yeah.
Thanks, Trina. Thanks, Gretchen, for elaborating on this. So let us play a little bit more on the factors that Gretchen were talking about earlier. What happens if the products were sold in different packaging and at different price point? So the level of sophistication to the target customers are different. Maybe the one that has been registered for over 10 years and operating for over 10 years is targeted towards a more sophisticated market. And Mary's makeup brand is targeted towards a more, maybe a more junior market. Would that make a difference?
That is a factor that the court will consider. But this, again, it will depend on the evidence that you submit, because as we talk about the last hurdle that these botelicious have to prove that there's infringement, is that there's a likelihood of confusion. And the relevant public that they need to refer to will be who is going to buy this product. So here you have mentioned that there are two different price points. They are sold in different channels. So that means that the people who are going to buy Mary's products are not the ones who are going to buy botelicious products. So if Mary is able to prove, that there's no overlap, there's no way that, my consumers are going to, confuse between these two because they would not have bought the other product in the first place, then that is a possible point of contention. She can try to argue this point if, this matter goes to trial, to say that there is no likelihood of confusion because the relevant public, there is no similarity in the relevant public. Okay, that means the relevant public that would have bought botelicious products would not have bought mine, and vice versa. So this is again a factual and evidential point that you will need to prove in court. So I have to say that proving such, gathering such evidence is very difficult. It will be quite laborious. And it can be expensive, especially if you're going to say get survey evidence. So yeah, I mean, that's the evidential point. So the best way is still not to get to this point.
That's absolutely right. Thank you, Gretchen. So let us play out this scenario a little bit more. So a claim of trademark infringement has been made out. What then would Mary's defenses be? Gretchen, what would you suggest her next course of action should be?
The next course of action, well, okay, so if the infringement has been made out, she will need to see whether she can rely on any of the defenses to infringement. But they are very limited fair use defenses. I mean, we also have a concept of fair use under trademarks. So like one is the honest use of your name or the name of the place of business. So I mean, this is a very historical fair use, where back then when, say, two people named Robertsons, say, for example, set up shops and then they selling exactly the same thing. So that is a fair, I mean, I would say that is hardly ever used these days. And then there's an honest use of the sign to indicate the purpose of the goods. That means this product is, that means the brand, say, is a fairly descriptive term. Okay, it indicates exactly what the product is meant to do. Okay, but in this case, it is very unlikely to apply because botelicious or beautylicious is not a word that you can find in the dictionary. Generally, if a word is not found, you cannot find it in a dictionary, you cannot find it in, say, a Wikipedia page, it will just be deemed as a coined word, it's an invented term, and it will just be considered as distinctive, and it can be used as a trademark. So it is very unlikely that it will apply again in this case because botelicious is an invented word. Then another possibility is Okay, but again, it doesn't apply here. Okay, if say that Mary had already been using this since like 5 years ago, okay, and only now that Botylicious discovered that Mary is also using a similar brand, okay, then there's a possibility that, you know, she could have say that I've been using this before you even registered this mark. I didn't know that you were registering this mark, but I have been using this for a very long time, so I should be allowed to continue using it. Okay. Then there's other fair users, say for non-commercial purposes or news reporting, news commentary. But I think for Mary, it is quite unlikely that she'll be able to rely on any of such defenses. Yeah, so okay, in the event, you know, if you have come to this point where they have proven a prima facie case and you have trying to, you know, find defenses to it, you are probably in a fairly hard spot already. I would say that if I were advising Mary, I would tell her that, okay, it looks like your case is not so good, or if you want to settle this with Botylicious out of court. Okay, so this is where I would you can consider mediation, okay, or even just private settlement. Private settlement means either with your lawyers or just by yourself, you reach out to Botylicious to try to reach a settlement agreement, or you can resort to mediation. So there are several mediation centers in Singapore. We have the Singapore Mediation Center, Singapore International Mediation Center, and there's also the WIPO Arbitration Mediation Center, several, and also private mediation centers where you can get a mediator who is a impartial, neutral party who is able to manage, you know, the expectations of both sides and bring them to a neutral forum for them to talk out all of their requirements and whatever remedies that they're seeking and come to a private settlement. So for example, and mediation is unlike court. You can be very, very flexible. It can be very creative. So we have already talked about remedies in court, basically an order to do something or to just pay money. So it's not very flexible at all. In the case of IP especially, sometimes the best solution is actually not what the courts can give you. It can be, say, cross-licensing. It can be a coexistence agreement, which we see a lot of. And in this case, if Mary is an influencer, she can offer, you know, certain services to Botylicious, say that I could make a public apology, say that I did not know that I was infringing your mark, but, you know, Botylicious is so kind and generous that they have instead decided to work with me. And then say that Mary will say, okay, as part of my settlement, say I'm just an influencer, I just started out, I don't really have a lot of money. What I can do is I can promote your products for free. So say I have a series of 10 Instagram posts promoting your product. Usually I would have charged how much, but in this case, because it's my settlement to you, I'm doing this for free so that you don't sue me or you withdraw your claim against me. And then after that, you know, if it works out well, maybe Botylicious will decide I will continue hiring her as my influence, to promote my brand afterwards. So basically, these are the creative solutions that you can come up with in mediation, which you will not get in the courts. So this is something I would have recommended her to do.
Thanks, Gretchen. Thanks so much for explaining the alternative dispute resolution settlements as well. So I noticed that we are a little bit short of time. So let's move on next to our Q&A segment. I'd like to remind our audience that you can still submit questions. So for the first question, how are fees charged for registering IP? Does IPOS have guidelines, standard rate for such services? Trina?
Okay. There are statutory prescribed registration fees. And for that, you can go to the IPOS website, and under the fees tab, you see how much it costs to pay for registration of a trademark, to file a patent or file a registered design. Now, you can do it directly. As I said, you can, everything is online now. You can file directly through our website or through the mobile app. But if you wish to get professional legal advice on, for instance, is your mark considered distinctive enough to fulfill the criteria for registration, or you're not too sure exactly what goods and services should be covered, then you would go to a IP lawyer like Gretchen, who will then, for a fee, charge you for giving you advice. But, I mean, I'm sure the rates in Singapore are very competitive. Yeah, I don't know, Gretchen, if you want to add on to that.
I think mostly what the external advisors can value add will be basically finding strategies, say what exactly are, what are you trying to protect? What is the business that you are doing? And besides trademark registration, for example, do you have any other IP that you need to protect? And can we cover you in other ways? So that is the value add that IP advisors. It's some IP advisors are not necessarily lawyers, okay, but yeah, they have IP strategists as well that you can reach out to. So they can advise you on strategy, and also say that if you are looking at, I guess, content creators or online influencers, if you're going to launch a product, you're usually, since you're online, basically there's no border. Most likely you're looking at not just Singapore, but say the region or certain territories around areas like, I don't know, Malaysia, Indonesia, okay, or Vietnam, Thailand, so on. So, I mean, that is maybe where you will need strategists who will be able to help you with filing in all these different countries, because of course, there's additional cost and you may not be able to navigate it that well. Whereas, I mean, in Singapore, if you're just interested in Singapore, iPod's website is actually really easy to navigate. In fact, you can just pay by credit card. It's really, really easy.
Thanks, Trina. Thanks, Gretchen. That was very helpful. So on to the next question. I have written a documentary script which was intended to pitch to a production house to produce the idea. How can this person then protect this idea and still hold rights to the script? Trina, would you like to take this one?
Sure. I'm happy to take it. Before I joined IPOS, I was in practice, and I did a lot of work in the media field. And so this is actually a very common question. So I had to actually split it in two parts. Firstly is, how do I protect my idea for this documentary, for this TV show? As Gretchen had explained, ideas are not property in that sense. There's no copyright. Copyright doesn't protect it. When it's still in that initial stage of pitching, and you are very afraid that who you pitch it to is going to take the idea and run off and make their own documentary, you can pitch the idea through and make under what we call confidentiality obligations. So you can get them to sign a non-disclosure agreement, or NDA for short. Or if you feel that the production house might be a little bit wary about signing, then you need to tell them, my idea is confidential. When you email it, you need to watermark the document on which you have penned down your idea, confidential. You need to put in your email subject header, confidential. You want to, in very Singlish, double, triple confirm. In your email, you can actually say, look, this idea is confidential. You should not be, distributing or discussing with anybody except me. So once you have put that production house on notice that this is confidential, if they were to run away and with the idea and do it themselves, at least there's some grounds for saying, look, they breach confidence. So that is for the idea. Now for the script itself, it is a form of copyright work. It's called a dramatic work. And in Singapore and everywhere around the world, actually, you do not need to register to own copyright, unlike a trademark. It arises automatically upon protection, the minute you put pen to paper or you type it out. And there are various ways that you can prove that you have copyright. So the most important is to actually include a copyright notice on your script, the C symbol, and then put your name and the year of creation. Keep records of how you put of your product creation of the work. Some people will even mail it to themselves so that you have external evidence of a time date stamp. Now, some countries have a copyright registry. Again, not because you need to register to get protection, but it provides evidence. So for the one that is actually really heavily utilized, and not just by its own citizens, is the US Copyright Registry. And in fact, a lot of people in the media field register their scripts, their CDs, their videos with the copyright registry in US, and it can be done online. That's the wonder of the digital world we live in now. You don't have to instruct somebody there to go and send a hard copy to the Congress, because the copyright registry is housed in the Library of Congress. So it used to be somebody has to go down there and hand over a physical copy, but now it can be done online. The fees range from like US $50 to 130, depending on the type and content. And that certificate of registration is your proof, your evidence that you own the copyright. So that's why this answer has to be looked at from both in two parts, the idea and the copyright. And once you have produced a show, the idea is out in the public domain. It's no longer confidential anymore, but the script is still yours. It's still copyright protected by, and it's owned by the scriptwriter, unless of course he assigns the script to the production house.
Thank you, Trina. So speaking of the US, one of the questions actually mentions it as well. So let's say a photographer work is reproduced overseas, for example, in the US, without permission or credit. Can the photographer take action?
So for this type, the new right of attribution, new right to be identified, what actually is called moral rights in the international sphere, they are territorial. So under the new Copyright Act, if your rights are not infringed by any act done outside Singapore, that's provided under the Act.
Thanks, Trina. Gretchen, would you have anything else to add to that?
Yeah, but I would just say that your copyright was still recognized, because all of the, why copyright does not need to be registered is because it's just generally recognized around the world that especially in all countries that are members of the World Trade Organization, is that they will automatically recognize the copyright of that is of a work that is created by someone who is a citizen of that country. Yeah.
So it's the two layers again. That person has reproduced his photograph in the US without his permission. There is copyright infringement. He can sue, but it must, because you sue under the laws where the infringement takes place. So your claim is under US laws. But under US laws, they will recognize that there is copyright in the work due to the World Trade Treaty, World Trade Organization Treaty, and other international regulations, because copyright law is largely harmonized around the world. So it's not difficult to get countries to recognize it. But the separate act of attribution, that is really, really territorial, because not every country has it. An increasing number of countries have it, like the US, UK, Australia, and we took a lot of reference from the UK's laws in creating it. But it's not something that is internationally recognized or harmonized yet, which is why we do not want to give the wrong impression that you can sue people in other countries as well. So our new act says very clearly that it does not extend to acts done outside of Singapore. Maybe in time to come, when we reach a certain level of harmonization, then yes, you can go after that chap in the US or anybody who is in any WTO country. Yeah.
Thank you, Trina. Thank you, Gretchen. So another question that we have from the audience: if this person is going to design a teaching program with a friend, but he has been approached by a company that wishes to run the program under his name, how do they protect their IP?
So when they say a teaching
Gretchen?
program means, I'm assuming it's a suite of, teaching, I guess, you need teaching materials.
Yeah.
So I guess, yeah, there will be copyrighted materials, certainly. If they want to run, and a company wants to run the program under its own name, you can, in what we described, exploit your IP. That means what you have created is copyrighted works. You can license it to the company. So there are various ways you can, it can be a sole and exclusive, which means you yourself will not be using these materials. The company will be the one using these materials to run the program. And in return, say they will pay royalties to you, like a certain percentage of the fees that they collect, for example. Or you can assign it away. That means you sell the materials to them and you work on something else. So yeah, there are different ways of exploiting this, but how do you protect? As mentioned, if it's a copyrighted work, you don't need registration. You just need to prove that you created it. So like all the draft that you created and then the final date that it is done, for example, then just retain evidence of that. And yeah, that's all. That's all you need.
Thank you, Gretchen. Trina, would you like to add to that?
Not really. I think Gretchen covered all grounds. It's like the documentary film scriptwriter, you first have to prove that or assert your ownership before you can exploit it. So similarly, I would imagine that, the teaching materials, there'll be a pedagogy, syllabus and things like that. You should have your copyright notices first. And of course, it's very important to have the agreement with the company that wishes to run it and state very clearly who is the copyright owner and who has what rights. The thing about copyright is that we have what we call default positions under law. But these default positions only need to be invoked if people don't have well-written contracts or are completely silent on who is a copyright owner or who has what rights. Then you have to go to the default positions. But otherwise, it's really a business asset that you trade in. So you must capture it clearly in writing who owns it, who has rights to it, who can use it, and for what purposes.
Thanks, Trina. That's really helpful. So in terms of giving some tips to the audience, what would you say would be the key things that they have to include in a contract to protect their rights?
As mentioned, you should always try to capture it in a contract. So firstly, you must state, well, who is going to be the owner, okay? And then if you're a license, then what are the rights that you're granting? So I think in the slides that we had shown earlier, there was a exclusivity, duration, purpose, something like that, and territory. Yeah, so these are all the areas that you should cover. So limit the rights granted appropriately. So these are the things that you should capture within the agreement.
Thank you, Gretchen. We are sadly running out of time, so I'd like to invite each of our speakers to leave us with one key takeaway. Gretchen, would you like to start?
Okay. I'm starting, but I'm taking this concept which just now Trina had mentioned, which is that as content creators, you are not just people who create content, you are also users of content. So I think one thing I at least like y'all to take away is that if you want someone to respect your ownership rights, your IP, you should also respect other people's IP. So how do you respect other people's IP? You have to recognize that they own it, get permission if you want to use it, attribute it properly. So this is how you respect their rights. Otherwise, it's difficult for you to demand other people to respect you in return. So I think this is a give and take, and it's a mutual respect situation that everyone should just keep in mind, because I have had people who come and say, oh, they infringe my rights, but when you ask like, how did you come about this in the first place, and oh, actually they copied it from someone else. So it makes me quite speechless when I hear such cases. Yeah, so just respect others, and do the same to others as you would like them to do to you. Yeah. Thank you.
Thank you, Gretchen. That's really helpful indeed. Trina, what's with
that was beautifully said by Gretchen. She stole my takeaway. No, actually, another point maybe I could add is, as when we saw for the case study, it's just a reminder that to everybody out there that copyrights are really a business asset. Not like IP rights are business assets, right? You have in your product, in your content, you have so many things in which you can exploit. You can sell it away completely, but you can also like chop it up, and say, all right, I license to A for Singapore, I license to B for Malaysia, and I license to C for Europe. It's something that you need to think about, that it's also a business asset. And so therefore you really need to educate yourself on what your rights are and what you can do with it. And to that point, IPOS also has IP business clinics. So the legal clinics are to help you when your rights are infringed or somebody accuses you of having infringed their rights. But we also have business clinics where you meet with consultants and IP consultants or IP lawyers, where you need to know some of the questions that you just asked. I developed this wonderful teaching system and I want to get others to run it, but I'm not sure how I should package it or license it. Again, it's 45 minutes and it's a free session, and to help you get started on that journey as to how to not just protect, but how to manage and commercialize your ideas and your intangible assets.
Thank you, Trina. That was indeed very helpful. I'm afraid I have to bring this webinar to a close. So for all the audience, please scan the QR code or visit the website www.cdc.gov.sg/law-awareness-weeks to find out more about the other webinars under Law Awareness Weeks at CDC 2021. Relationships are precious. Heal relationships with those around you. After this webinar ends, a feedback form will be shown in your browser for your completion. We appreciate if you could take just a few minutes of your time to complete the form so that we can improve our webinars. With that, we would like to thank Trina and Gretchen for sharing their expertise with us. I'm Abigail, and on behalf of the speakers, we would like to say a huge thank you to our participants for joining us today. Have a pleasant weekend ahead. Good night.
Thank you. Bye.